Where does civil rights law come from? Let's nail down the constitutional and statutory machinery because everything in this chapter rests on it. The primary constitutional source is the Equal Protection Clause of the 14th Amendment, ratified in 1868 after the Civil War. The language is simple but powerful. No state shall deny to any person within its jurisdiction the equal protection of the laws. It was drafted specifically to stop Southern states from using their legal systems to keep newly freed African Americans subordinate. But over the next century and a half, its reach expanded to cover virtually every form of classification-based discrimination by state and local government. Now here's a subtlety you need to catch. The Equal Protection Clause applies only to state action, to state and local governments. And notice there's no equivalent Equal Protection Clause that expressly applies to the federal government in the constitutional text. So how do we hold Washington to the same standard? The court solved this in Bolling v. Sharpe in 1954, decided the same day as Brown v. Board by holding that racial discrimination by the federal government violates the Due Process Clause of the Fifth Amendment. The doctrinal reasoning was a bit strained, but the practical result is clean. Federal discrimination is now judged by the same equal protection standards as state discrimination. But what about discrimination by private actors, employers, landlords, businesses? That's not reached by the Constitution directly. It's reached by federal and state civil rights statutes, enacted under Congress's power to enforce the Reconstruction Amendments and to regulate interstate commerce. And here, you need to know the major statutes. The most important is the Civil Rights Act of 1964. Know its key titles. Title II prohibits discrimination in places of public accommodation. Title VI prohibits discrimination by recipients of federal funding. And Title VII prohibits employment discrimination on the basis of race, color, religion, sex, or national origin. Title VII also created the Equal Employment Opportunity Commission, the EEOC, to enforce federal employment discrimination law. Beyond 1964, two more statutes round out the framework. The Fair Housing Act of 1968 prohibits housing discrimination, and the Americans with Disabilities Act of 1990 prohibits discrimination against persons with disabilities in employment, public accommodations, and government services. So keep this architecture in mind. The Constitution handles government discrimination through equal protection, and statutes handle private discrimination. That division of labor structures every civil rights battle we're about to examine.